Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about a dispute between three parties that actually are a number of parties, but we're going to treat them as if there's just a plaintiff, there's a third defendant and a fourth defendant. And when we use the term plaintiff, we're sort of referring to a natural person who's the director of a relevant company and some shareholding interests. We're referring here to a natural person, the defendant 3, defendant 4 to a natural person, but also to some corporate entities related to them. So there'll just be a little bit of a shorthand. Short point is, each of plaintiff, defendant 3 and defendant 4 own a third of a company. And what that company does is provide consulting services to the Australian government, particularly to defence. And they enjoy some success over the years. And the projected earnings in some of the relevant years are in excess of $10 million annually, and there's a version of the future where it's even in excess of that. So it's a consulting services company of some size, some heft, some weight, and some value. Sadly, relationships between each of the directors sort of devolve over time, and there are tensions that arise. Now, what happens is our defendant 3 and defendant 4 resolve, essentially, after there's some tensions that, as I say, arise over time, that the plaintiff is a complete dud, and they form the view that they no longer want to be in business with the plaintiff. They form the view that the plaintiff is not of value to their view of the future trajectory of the company. And they form this view for various reasons that are no doubt entirely reasonable to themselves, and it's no doubt a well held view by them, with no comment made as to whether it's actually a legitimate view. It's certainly a view they have. And so what they do is they progress with a strategy to sort of get things moving. As part of that strategy, they consult with ChatGPT, that is an LLM, a kind of word guessing machine, sort of provider of AI services that some of you might have heard of. And so, as you probably know, the way you use this is you plug in your issue, and it'll spit out a kind of result for you. And that is the sort of advice they take. They say, and we don't see the prompt they use, but in essence, they put a strategy into ChatGPT and say, we'd like to remove this person, this director, and ChatGPT spits out an answer. Now, the fact that it's the use of ChatGPT isn't super relevant, but what is super relevant is the nature of the strategy that evolves from putting in this prompt essentially treats the director like an employee. And as you and I know well, the status of a person as the director of a company is different to the status that person might have as an employee of the company. And the way you exit an employee that might be on the basis of what some of us refer to as PIPs, or engaging with the performance of that employee, is one element of looking at the world, but the way you engage with a director is quite different again. Now, because the firm itself was formed on the basis of some sort of non-legally binding principles, there's this idea of equality, of kind of equal contributions to the work, and potentially equal outcomes financially as well. But because these are non-binding, we don't get into it too deeply. But the short point is, a view is formed that the plaintiff is not making these contributions in the way that defendant 3 and defendant 4 would like. And so they pursue this LLL-informed, complete dud exiting strategy. Now, this sort of culminates in a meeting in February 2025, where pursuant to this sort of employment-only approach, there are various steps taken. And we don't need to go into the minutiae of them. The sort of outcome of them is to try to sort of exclude the plaintiff from the ongoing steps in the business, to sort of exclude them from engaging with new clients, to sort of get them off the tools, to sort of force them out of the business, and as well to sort of direct dividends away from the plaintiff. So there's going to be financial pressure applied to the plaintiff as well. There's some evidence suggesting this is how the parties exited a shareholder sometime in the past as well. But in short, they undertake this strategy, this sort of employment-flavoured strategy to exit the plaintiff as director and shareholder, and things sort of build to a head where the plaintiff engages lawyers, as you might imagine, makes a complaint via those lawyers. There's then a bit of an exchange of offers, but in short, there's no resolution reached. What the court finds fairly comfortably is, look, the breakdown of trust and confidence between the plaintiff and Director 3, Director 4 would be enough to ground what we call a Section 4611K order, a just and equitable winding up of the company. It's also sufficient to establish that there has been oppression pursuant to Section 232 of the Corporations Act. And if it wasn't interesting enough already, here's where things get really interesting, because if the court finds that oppression has been established pursuant to Section 232, then the court may make an order pursuant to Section 233. And the purpose of that order is to end the oppression, to bring it to an end. What corporate disputes lawyers like me often say is that you're sort of going to have two alternatives in relation to the making of orders of that kind. Alternative one is going to be a share sale where the court says, all right, you buy their shares out for X dollars, sort of a court-ordered share sale, court-ordered buyout, share buyout. We sort of use terms like this for that. And the alternate, we often say, in this sort of dichotomy, is a winding up. So it's like either we're going to go down the path of a wind up or down the path of a court-ordered buyout, that, as you might imagine, is often informed by the evidence of an expert valuer who says, look, if the court's going to make a buyout order, it should be worth X dollars. You and I might have different experts, and my expert might say, oh, when you say X dollars, it should actually be X dollars minus Y. And I say, no, well, if anything, it should be X plus Z. And you know, we have these fine calculations or fine arguments about the way these valuation calculations are conducted. And indeed, that is the position that arises here. And what the court finds is there is no decisive assistance it can obtain from one valuer who it finds uses a methodology that the court finds is not of assistance and sort of goes into the sort of academic underpinning of one of these methods of valuation. And the other expert treats the risk, the single client risk, if we can frame it that way, the risk of just having the Commonwealth government, defence as your only client, and the fact that defence can terminate any contract just for convenience because they feel like terminating it, finds that this other expert didn't really bear in mind the risk, this sort of single client terminate for convenience risk in mind properly. And so the court finds can't be assisted by this person because of this methodology problem, can't be assisted by that person because of this failure to engage with this risk properly. And so I don't really have a clear sight of the valuation. Now you'll remember when we discussed Section 233, there's this buyout versus wind up issue. And so you and I might say, well, okay, it's not a buyout, I guess we look towards a wind up. And you might recall as well, we mentioned Section 4611K that relates to the just and equitable winding up of a company. And so you might think, well, I guess we're looking towards a liquidator. And in a court, and in short, the court does consider a liquidator, but then goes on to consider a line of authority, some of which is English, in relation to the appointment of a receiver, not to the company, the consulting services company itself, but to just the plaintiff's shares in the company to go ahead, take possession of those and cause them to be sold with the outcome to then go to the plaintiff, if that makes sense. So it's not a receiver manager who would come in and run the company and take over it. It's merely a receiver who comes to be the owner of the plaintiff's shares to go ahead and effect the sale. And what the court finds is that after consideration of, yes, there was oppression, and so I want to make a Section 233 order. I can't make a share buyout order because I don't have evidence that assists me to understand the value. I don't really want to make a winding up order because it's a viable company and you don't want people to be out of jobs and you don't want to destroy contracts and these sorts of things if possible. And so the court orders that a receiver be appointed to cause the plaintiff's shares to be sold and for the proceeds after payment of the receivers to flow to the plaintiff. So we have this, so almost, it's not a Pyrrhic victory because it is a genuine victory for the plaintiff, but one might imagine there's a degree of disappointment on the plaintiff's part where they win entirely on what we might call the oppression point or the Section 232 point. The court says, yes, indeed, there was oppressive conduct, but there's sort of an additional layer of complexity that may not have been on the plaintiff's wish list in relation to dealing with the outcome in relation to those shares. I hope that discussion assisted you, and I look forward to speaking again soon over another coffee and in respect of another case note. Cheers.